Okay, hi, this is Ari Sauer, the Immigration Answer Man. We are trying this again. I was having some video trouble before. Hopefully we will not have any problem this time. Again, it is Monday, August 21st, 2017. Here I'm going to discuss about some recent news in immigration law, as well as answer your questions. I hope that if those of you that are watching this live will comment, let me know that you're watching, ask your questions. I like this to be interactive if possible. If you are watching this recorded, hopefully you will also make comments. Let me know you watch this. Let me know what topics you would like me to cover in future videos. So let's start. So in the past week and a half, one of the things that's happened is that right before the Senate left for the break, Senator John Cornyn from Texas introduced the Building America's Trust Act, which is Senate Bill 1757. What that would do if it passed is it would authorize $15 billion towards border security. It would and immigration enforcement. It would create a need for or require DHS to introduce unmanned drones throughout the border, as well as encourage facial recognition programs. It would also create a biometrics data collection system upon entry and exit in the 15 busiest airports. It would also allow for more Customs and Border Patrol agents. There's also some additional language in there from a previous bill called the Stop Dangerous Sanctuary Cities Act, which would create penalties for local law enforcement that are not turning over undocumented immigrants. In other news, the Senate Bill 4 of Texas, SB 4 in Texas, which is a law that was passed for the state of Texas that would create punishments for those cities within the state of Texas that are considered to be sanctuary cities, quote unquote sanctuary cities. The state went ahead and filed a suit to try and get the bill determined as constitutional ahead of time. They did this because there were similar law in Texas that was, at least in part, found to be unconstitutional. This bill, the court determined that it was too early because the bill doesn't go into effect. The law doesn't go into effect until, September 1st. The law goes into effect September 1st. And because of that, the courts throughout the case said it was too early for this suit to be filed. So we may see this suit being filed again after September, either by the state of Texas to try and get it determined that it is constitutional, or once they start enforcing it, we will see those parties within Texas who are being hurt by this, the cities and or the individuals that are being hurt by this program, go into effect, and so we'll see one or the other will file suit. So we're not at the end of this, but for now, the courts have refused to make a determination on the bill. In similar news, Attorney Jeff Sessions has previously, Attorney General Jeff Sessions has previously announced that the U.S. government will be withholding funding for those cities that they determine are sanctuary cities under the Edward Byrne Memorial Justice Assistant Grant, the Byrne JAG program, which is a program that allows for federal funding for local governments, for local law enforcement. And the current administration has said that they were going to withhold funding from local cities and counties that are determined to be, sanctuary cities. They would withhold funding of this Edward Byrne Memorial Justice Assistant Grant, which is this funding is important to local governments. They rely on this funding for their police. In response to this, the city of Chicago on August 7th filed a lawsuit against the Attorney General's office. On August 11th, so the city of Chicago filed in Illinois. On August 11th, the city of San Francisco filed a similar lawsuit against the Attorney General in District Court in California. And on August 14th, the state of California also filed suit against the Attorney General's office in the state of California, the Federal District Court of the state of California, to stop the Attorney General from being able to withhold this funding under this new program. So we'll have to wait and see what happens with the program. Those are just at the beginning of their process, and because we are looking at district courts in two different states, this is something that we may end up seeing go up to the Supreme Court. All right. Very important news regarding the DACA program, Deferred Action for Childhood Arrivals. Previously, those of you may know, previously there was an attempt to expand the DACA program under the previous administration to create the DAPA program, Deferred Action for Parental Accountability. The DAPA program would have created a similar program to the DACA program for certain parents. But the state of Texas and certain other states filed lawsuits against the Obama administration and were able to stop that program from going into effect, went all the way up to the Supreme Court, and it was determined, well, the Supreme Court wasn't able to overturn that decision of the lower courts, so that program never went into effect. In June, President Trump officially withdrew the DACA program from the books, took off the executive order that put that program, tried to put that program into place. And so, but when he did so, he chose not to withdraw the DACA program. So the DACA program, which never went into effect, was officially withdrawn. The DACA program he kept in place. Now, the state of Texas and several other states are threatening to sue again unless the president withdraws the DACA program. They said they've given him a September 5th deadline to withdraw the DACA program, or they're going to file suit against the government to stop the DACA program, or try to stop the DACA program. Now, the DACA program, part of the logic that went into the courts agreeing to stop the DAPA program does not apply to the DACA program. So the DACA program, for a number of reasons, is in a much stronger position. The problem is that if these courts sue, then it's the government's duty, or not government's job, to decide whether or not to fight this. So the problem is if the states file suit and the Obama administration, if the Trump administration decides not to fight this, then those states will win, and the DACA program will lose. We will lose the ability for the DACA program for additional extensions, and the program will sunset. So it's very important. Those of you that are watching, let your friends know, let everybody know, call your congressman, call your senators, call the White House. let them know that you want them to support the DACA program. I can't emphasize how important this is, because at this point, the president has the option to end the DACA program just by doing nothing. So it's very important that you, again, call your senators, call your congressmen, tell them you want them to support the DACA program. Tell them you want them to support the DREAM Act. Let's bring the DREAM Act, make it a reality, end this the DACA program, which is in some ways a Band-Aid approach, and let's make it final. Let's help these dreamer kids for good. But also, I want you all to call the White House and tell them you want them to support the DACA program, to defend the DACA program. So we really need to bring out the support. Let all your friends know. All right. Let's see. All right. Regarding the H-1B program, we are seeing, us being immigration lawyers, are seeing trends across the board of requests for evidence on the H-1B applications like we've never seen before. Both in the number of requests for evidence that we're seeing on these and the types of requests for evidence. New issues that have never been brought up as issues before, the government's now going after. Cases that were strong cases are now being questioned. It appears that the government is trying to use the request for evidences as a way to change the program without having to go through the legality of actually changing regulations. So it's an attack on the H-1B program that we're seeing right now. Groups like the American Immigration Lawyers Association, the American Immigration Council, immigration lawyers, we are combating this. But again, if you want to see the H-1B program continue as something that is viable, please call your congressmen, call your senators, let them know that you want them to support the H-1B program. All right. In more recent news, Department of Homeland Security has terminated the Central American Minors Program, the CAM program. It was a little-known program which allowed certain children of certain who had parents who were here in lawful status, kids that were from El Salvador, Guatemala, and Honduras, which would allow those eligible kids to obtain a refugee status, to be able to come to the U.S. to join their parents here in the U.S. That program has been terminated, effective immediately. It's very frustrating because we're talking about kids who are very much in danger and who are children of people who are here legally, permanent residents and non-immigrants who are here legally, doing everything right. It was a way for them to help their kids, protect their kids, and now this program has been ended. One of the many ways that we are seeing the current administration not just go after undocumented immigrants, but also go after legal immigration and try to end legal immigration or hurt legal immigration as well. In addition, the Department of State has just announced that they are going to be temporarily putting a halt on any non-immigrant visas from Russia. My understanding is this is due to Russia limiting the personnel at the U.S. embassies and U.S. embassy and consulates in Russia. So there's going to be a temporary halt on that. When it resumes next month, there is going to be limited issuing of non-immigrant visas. All right, so I had some questions sent in. If you have any questions that you want me or issues you'd like me to talk about, if I can talk about it, on the fly, I'm happy to try. So one of the issues that was brought up is one of my watchers, readers, asked me to talk about sponsoring of siblings, brothers and sisters. So first of all, only U.S. citizens can sponsor their siblings based on their family relation. Permanent residents aren't allowed to sponsor siblings, and other non-immigrant status obviously cannot sponsor siblings. So it's only U.S. citizens. It is a two-step process. The first step being the filing of an immigrant petition, an I-130 form. That is to show the U.S. government that this is a valid sibling relationship. That petition, right now they're taking a very long time to approve those petitions, but the only reason why they're taking so long to approve those petitions is because for the second step, which is the actual applying for the immigrant visa or adjustment of status, you have to first wait for a visa to become available under that petition. And it's a very long wait. So the actual filing of the petition doesn't actually grant the person any status or any actual immigrant benefits. It is just a means to eventually allow that person to apply for an immigration benefit. By the way, if you're just joining us, feel free to add your comments, ask questions, let me know you're there. All right, so siblings filing petitions for permanent residents. All right, so first step is they file the petition. After that, we have to wait for a visa to become available. Right now, the wait is very long. There are only a certain amount of visas given out in this category each year. There are more people that apply each year than there are visas available, which creates a backlog. Currently, when we're looking at the September visa bulletin, which will take effect September 1st, we're looking at January 2002 for most people, which means that for most applications, a petition that was filed by a U.S. citizen sibling back in January of 2002, that sibling is now able to apply for an immigrant visa or adjustment of status. If we're talking about Mexico, we're talking about even further back, September 1997. And then for the Philippines, it is June of 1994, meaning someone files a petition for their sibling from the Philippines. Back in June 1994, they are now able to use that petition to apply. So we're talking a very long wait. Now again, 2002 to now, that does not mean that we're looking at a 15-year wait. That means that there are 15 years worth of applications ahead of the line for someone who is applying right now. So that could be 10 years, it could be 50 years, no one knows. Not even the Department of State, the people that make this list don't even know. And if there's an interest in going into that topic, that can be the subject of another video. All right, so once a visa is available, then if the person's abroad, they're applying for an immigrant visa at the consulate to come into the U.S. If the person is in the U.S., in some situations, they're eligible for to apply for adjustment of status, apply for a green card here in the U.S. without having to leave the U.S. But in order for that to happen, they either have continued to maintain status this entire time, which is a rare situation because we're talking about so long. It's rare that you see someone who has maintained status that long and not been eligible to get a green card, permanent residence through some other way, but it happens. Or if the person hasn't maintained status, they'd have to be eligible for 245I amnesty or some other exception to the rule requiring you to maintain status the entire time. And someone who hasn't maintained status, we could be looking at them potentially applying for the immigrant visa abroad. But again, someone who's been here out of status for more than a year and leaves the country, has been unlawfully present for more than a year and leaves the country, they'd be looking at triggering a bar of inadmissibility for 10 years. Okay, that's the 212A9B bar, also known as the 3 or 10 year bar, or the unlawful presence bar. And we can cover that in more detail in another session if they're interested. So it's important to understand that just the filing of the petition doesn't give anyone status, doesn't keep someone here in status. They have to otherwise continue to maintain their status if they're in the U.S. Throughout. Someone who's able to, waits that long time, applies as a sibling for the immigrant visa. They are allowed to have derivative beneficiaries. So they're allowed to bring their spouse, and they're allowed to bring unmarried children who are under the age of 21, or who are over 21 but protected by the Child Status Protection Act. All right, just to use this moment just to remind everybody that this is just general information. It might apply to you, it might not apply to you. This is not to be used instead of having a consultation with an immigration attorney, because I'm just giving a general overview here. There's very specific, detail-oriented issues that come up that it may or may not apply to you. So that being said, I was also asked to talk about advanced parole for DACA. Those who have DACA, Deferred Action for Childhood Arrivals, are able to apply for advanced parole travel document. In order to get that, you have to first get DACA or renew your DACA. You can't file the application with your DACA application. The reasons for being able to obtain advanced parole travel document are either if there are humanitarian reasons, so for example, to obtain medical treatment abroad, to attend a funeral for a family member, or to visit a sick or elderly relative, for example. Those might be reasons that USCIS might grant advanced parole. Also, for educational purposes, for example, a semester abroad program would be an example, or for employment purposes, such as to attend a conference abroad or to receive training abroad. The advanced parole is only for a specific window of time, so it's not going to be granted for a year or so like some other advanced parole programs are. Especially right now, it's not without risk to use the advanced parole because right now there's the possibility that the program may stop. It's really up to whatever the president does. So I wouldn't advise using the advanced parole for really long periods of time. It's for use in specific purposes. The person who asked me this question was asking about using advanced parole so that they would then have a legal entry. And just to explain what they're asking about is there was a case called Matter of Arabelli. Matter of Arabelli said that someone who traveled on advanced parole, who entered on that advanced parole, would now have a legal parole for purposes of immigration, but on the other side, they would not have been considered to have left the country. that would then trigger the 3 or 10 year bar that I was talking about. So someone who has unlawful presence of more than 6 months or more than a year, obtains the advance parole, leaves the country, comes back in, they have not then officially left the country for purposes of triggering this 3 or 10 year bar. So that's a real benefit. And what it means is that, let's say someone came in without inspection, what we call EWI. They came across the border, were not inspected by an immigration officer. Someone who does that, let's say they marry a U.S. citizen, okay? They are not able to apply for adjustment of status, a green card, here in the U.S., okay? But someone who is married to a U.S. citizen, someone who's married to an immediate relative is in the immediate relative category. So let's say that counts spouses of U.S. citizens, parents of U.S. citizens, but the children have to be at least 21 years old to petition their parent, or minor children who are unmarried and under the age of 21 of U.S. citizens, okay? So those in the immediate relative category who are applying for a green card on that basis, they are able to apply for adjustment of status, a green card, here in the U.S. without having to leave the country. But for them to be able to do that, their last entry in the U.S. had to have been a legal admission or parole, had to legally enter the U.S. So someone who came in without inspection is not eligible for this benefit. They would have to leave the country, apply for the visa abroad. The problem is, in that situation, they would trigger that bar, and they would need a waiver to be able to obtain the visa and come back into the U.S., and they may or may not be eligible for the waiver. But someone in that situation who is, let's say, either a spouse of a U.S. citizen or parent of a U.S. citizen who is 21 or older, who last entered without inspection but is now eligible for the DACA advance parole, would be able to leave the country and come back in on that advance parole, and now they're no longer someone who entered without inspection. They are now someone who entered, who was legally paroled into the U.S., okay? And that allows them to apply for adjustment of status based on being an immediate relative. So it's important to understand that doing this only helps someone who would otherwise be eligible for an immediate relative adjustment of status. So for example, someone who has a sibling petition, or someone who is an adult child of a U.S. citizen, for example, who is in one of the preference categories, F1, F2, F3, F4, those categories are not eligible to adjust just because you entered with a legal entry. And just to explain that this doesn't get rid of any other inadmissibilities. So again, you should consult with an experienced immigration lawyer before you follow any of this advice. All right. It's also important to understand that what you're doing here, you're not fixing your immigration status, okay? You're still returning back into the same immigration status you were in before. So if you were out of status before, when you're paroled back in, you're still out of status. The only thing that's changed is that you're now someone who is out of status who has a legal parole into the U.S. All right, another thing that's important to know, especially, again, the person that asked this question had mentioned being in removal proceedings. Removal proceedings is the term that we use for someone who is, the government is actively trying to deport, who has a case before the immigration judge. Now, someone who is in removal proceedings, who obtains advance parole and uses that advance parole, they very well could be self-deporting themselves, okay? Because if you have an open case in the immigration court and you get the advance parole, you use the advance parole, you are now leaving the U.S., which is when you have that open immigration case, you are deporting yourself, okay? And that becomes an order against you. In order to stop it from being a self-deportation, you have to first get the case either terminated, which means completely ended, or you at least have to get the case administratively closed. Administrative closure means the case isn't over, but the case is put on hold. So if you get advance parole, even with DACA, and you travel with the advance parole, but you have a immigration proceedings, you have a court case that was not either terminated or administratively closed, then you have deported yourself. Before you get advance parole, before you travel on advance parole, and really before you travel in general, you should consult with a qualified immigration lawyer and find out exactly what your situation is. All right. There's a question, any chance of Venezuelans getting out? Have relatives there? Right now, I haven't seen any, let me check, I haven't seen any word of TPS or any program like that for Venezuela. Yeah, I mean, if what I would say is contact your congressman, contact your senator, contact the White House, get all of your friends and family to do the same, and ask the president to put TPS for Venezuela. That would help those that are here to be able to stay here. As far as those that are there, you can look into refugee status for them, but I don't know what the current status is with that. Let's see. Faisal, thank you for joining us. Thank you for your comments. All right, if anyone else has any additional questions, I'm happy to talk about it, happy to talk about whatever issues come up. Again, this is not meant to be instead of a consultation with an immigration lawyer. Talk to an experienced immigration lawyer. This is just to talk about general information, get the ideas flowing, let you know what's happening. Again, I ask all of you to call your senators, call your congressmen, ask them to support the DACA program, ask them to support the DREAM Act. It's really important that we support our fellow immigrants here. These are the most vulnerable immigrants that we're talking about here. Those that were brought here as children. So it's important that we do our part to help them out. I know there's been some protests, parades over the weekend in support of the DACA program, but there's nothing you can do that's better than calling your congressman, calling your senators, calling the White House, doing it repeatedly, visiting your congressman's office, your senator's office. Right now, they are on a break, which means they're in their hometowns. Go to their meetings. Ask them about the DACA program. Tell them you want them to support the program. Even if they're, you may think that even if they are Republicans and aren't going to listen to you, it's even more important that you go to them and you let them know, hey, I'm a constituent of yours and I want you to support this program. Because I can tell you that those on the other side are calling them every day and are visiting them and are telling them, hey, I love what you're doing on immigration. Yeah, let's stop immigration. And if we don't get out there in front of them and let them know that their constituents want them to support immigration, they're only hearing from the other side, okay? So I can't say this enough. I'm going to try and add some links to this to make it easier for you to contact your senators and your congressmen in your White House. But it is, if you don't do this, if we don't do this, all the complaining in the world means nothing, okay? They have to hear us to do, or they won't do anything about it, because I can tell you, I know that they're hearing it from the other side. All right. Well, thank you very much for joining us. If you are like us in the area of the eclipse, I hope that you will enjoy it. I got my little eclipse viewing glasses here, and we're having a little party at our office to watch. So enjoy, and if you're watching this the recording later, if you have any questions, feel free to post them. I'll try and respond if I can. If not, I'll also try and add these address the issues in future videos. All right, thank you all for watching. I appreciate it. Thank you.